Bismillahirrahmanirrahim. Assalamu alaikum. Welcome to the 18th lecture on the course Management, Organizational Policies and Practices. Let's have a quick recap of lecture 17 before we start with the lecture 18. During the lecture 17, we had a discussion on influences on employee behavior of a number of variables that are from the external environment and from the internal environment of the employee. In the external environment, we saw that a number of factors that are affecting the employee are from the macro environment, the technological factors such as the change in technology, how it can make the skills of some employees obsolete and how it can make them unemployable, and or how they need to change their skills accordingly to keep or to stay employable, right? Otherwise, how it has effects on their behavior, such as on their turnover or on the layoffs, etc., and the after effects of the layoffs. So there are a number of factors in the technological market that can affect the employee behavior. Similarly, there are a number of factors in the economic environment of the individual that can affect the individual's or the employee's behavior. And the inflation rates, for example, they can directly influence the employee's behavior. The changes in the interest rates and the market prices, the overall per capita income in the country, and other economic downturn or the economic upheaval, they all can influence the organization, and they can influence the employee and the employee's behavior ultimately. Then other factors, there can be certain political factors, they can be the legal legislations and the requirements from the law that can influence the employee behavior, and there can be a number of other factors such as the trade unions, the effects of the trade unions, the effects of the International Labour Organization, and the effects of the international bodies and agencies, etc. They can also influence the employee's behavior. So they are all the factors in the external environment, and from the external environment they are the factors in the macro environment, or in the most external layer that the organization faces of the environment, over which the organization does not have a direct influence. So of course the organization cannot influence if there is an economic downturn or if there is an economic upheaval, but that environment does affect the organization, and it can severely affect the organization, but the organization cannot affect this layer of the environment, which is the very external and the very macro layer in the environment, right? And similarly, the laws, the state laws and regulations, of course the organization cannot influence the state laws and regulations, but it needs to make its own laws and policies and organizational procedures in line with those laws and regulations. It needs to abide by those laws and regulations so that it does not have to face the non-compliance issues. Similarly, other regulations by the international bodies, they also need to be complied with by the organization for its smooth functioning, and for the compliance of the organization, the employees also need to comply, or when the organization has certain rules binding on it, it means that the employees working in it have those rules binding on them, and then those influence their they can influence their job designs, they can influence them in a number of ways, and thus influencing their work behaviors. So the relationship is quite indirect, but the relationship is there, and the relationship can be very strong in many cases. It is a significant relationship. Then in the other factors in the external environment, such as the co-workers, their influence on the employee. We had a discussion that the co-workers also can influence strongly the employee behavior by certain ways, such as if the employee is behaving positively, the co-workers, they may encourage him, and they may recognize his efforts, right? And then they may appreciate him, and they may praise him, and they may build good working relationships with the worker who they feel is abiding by the group norms or the organizational norms, right? But if the employee does not abide by those norms, then the co-workers, they may sanction that kind of behavior by discouraging the employee and by criticizing the employee in front of others, right? And that can basically be way but that can influence the employees' behavior. So that is a way to influence employees' behavior through the group activities, the group cohesion, the group trust, and the group cohesiveness, right? Then we saw that how the supervisors, they influence the employee behavior. We saw that the supervisors and the leaders both have a great role to play when it comes to the employee behavior, and we saw in the leadership that how certain leaders, they have certain characteristics which are really charismatic, and they influence the employees very strongly by inculcating in them the right motivation to work and to recognize with the organizational goals and to rise above their self-interests, and they inculcate in them the vision, the necessary motivation, and it changes their behavior. They are more they exhibit more organizational citizenship behavior. The employees exhibit better performance, better productivity. They are reported to be less absent with the organization, and a number of other outcomes that it has for the employee, and which are relevant to the organization as well, when the employees have the leaders who have the qualities of transformational and charismatic leaders. On the other hand, the employees who face the qualities of the transactional leaders, these attitudes and these behaviors are found missing in those employees. I told you that we'll be discussing all these leadership theories in detail, and then we'll have a detailed review of how these different leadership styles, they influence the employees or they influence the subordinates, and what are the different paradigms and what are the different outcomes of the different leadership approaches and different leadership styles. The supervision, we had a discussion that supervisors, we studied by way of the leader-member exchange theory, that how the supervisors, they influence the employees' behavior, they build good quality and bad quality relationships with different workers, and the outcomes are more positive for the good quality. The workers with whom the supervisors have built the good quality relationships, because they get better access to resources, organizational resources, personal resources, and thus as a result they perform better as well, right? And then we also had a look that there are certain factors in the internal environment as well which influence the employees' behavior, such as those are the factors that are related to the person himself or the employee himself, such as his knowledge, his skills, and his abilities. And we saw that skills and knowledge, they are the things that can be learned in the organization. Therefore, the organizations often provide the trainings for the knowledge building and for the skill enhancement of the employees. And these knowledge and skills, they enhance employees' motivation towards work, and the employees ultimately perform better on a number of activities, on a number of tasks, and as a result, they show better organizational and the individual behaviors. We also had a discussion that how the organizational factors such as the job design, it influences the employees' behaviors. We discussed that this in detail already with the help of the job characteristics model, that how the different conditions in the job, they can make the jobs more enriched, and how the enriched jobs can lead to better positive outcomes. Then we had a discussion on the other factors that influence in the organizational arena, such as the reward structure, and that is provided by the organization, or the other intrinsic motivators that are provided by the organization in the form of the participation opportunities to the employees, the recognition of the efforts of the employees, say of the employees in the organizational decision making, and so on. So these are all the factors that are coming from the organization, and they are influencing the employee behavior. And we had a detailed discussion on what is the mechanism that is followed by way of which the different factors in the external and the internal environment, they influence the employee behavior. So today's topic of discussion is equal opportunity and the law. It's a very interesting topic again. We'll see during this lecture what is the equal employment opportunity. We'll also see what is sexual harassment. We'll see the defenses which are against the discrimination allegations. right? And like if the organization is alleged to be involved in the discriminatory practices, then how it can defend itself. We'll see adverse impact, and related to this we'll be also saying the disparate impact and disparate treatment. Then we will be seeing the bona fide occupational qualifications, what are they and what are their implications. We'll be seeing them and how the organization can take defense through bona fide occupational qualifications. We'll be seeing the what is business necessity and how business necessity can provide an organization our defense towards these discrimination allegations to defend itself in those cases. Then we'll be looking at the discriminatory employment practices, that what practices are the discriminatory practices and how they are discriminatory practices, and under what conditions those practices cannot be termed as discriminatory, such as the recruitment and the selection standards. We'll discuss a number of practices related to the recruitment and the selection standards, and we'll be seeing that how those practices are discriminatory or how they can be termed discriminatory. Then we'll be seeing the different diversity management issues. Then what are the challenges that are faced by the organization when it comes to the diverse workforce, and how the managers, they are expected to manage that diversity. What are the positive and the negative outcomes of diversity, and then we'll be seeing the equal employment opportunity versus affirmative action. So we will be having a discussion of what is affirmative action and how affirmative action is different from equal employment opportunity. What are the different steps that are taken in the development of this affirmative action program. Then we'll be seeing that how the organizations, they can improve productivity through diversity management, right? And we'll also be having a look at how to recruit minorities online, and then we'll be discussing on what is reverse discrimination. This is the outline that or the learning outcomes from today's lecture. So we start with the lecture. If we start with the definition of the sexual harassment, that what is sexual harassment? Sexual harassment is an unwelcome sexual advances. It is a request for sexual favors and other verbal or physical conduct of a sexual nature that takes place under any of the following conditions. Submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual, and such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile or offensive work environment. So sexual harassment is that it is of course on the basis of the sex, and it's what is important to conclude from the above is that it substantially interferes with a person's work performance or creates an intimidating, hostile or offensive work environment, right? So when we'll be treating those cases under sexual harassment regime, or only those cases would come under sexual harassment wherein the victim's performance is in jeopardy. It's his organizational performance or his job performance. There are certain psychological effects or there are certain physical effects on the employee as a result of which he cannot perform his job well, right? So those cases, they will be coming under sexual harassment. But if there are some sexual advances that are minor or they're not affecting the employee's performance, then those cases won't come under the sexual harassment or the Sexual Harassment Act or policy, and they also cannot take any plea in the court. So proving sexual harassment, how you can as an employee prove sexual harassment, what are the different ways, or under what plea can you take that you have been harassed sexually. Before this, I would also like to tell you that most of us, they have developed this concept about the idea of sexual harassment, that it is only the harassment of women or of the females by males. So when the term sexual harassment comes in our mind, it comes in our mind that a female is being harassed. harassed. But that is not the case. Sexual harassment, of course, it can be both ways. A male member or a male employee, he can also be harassed by a female employee, a female co-worker, a female supervisor, or a female client, right? So it is the harassment on, it can be the harassment on both sides of the unequal gender. So okay, how you can prove this sexual harassment? There are a number of options, there are a number of possibilities which come under the category of sexual harassment, and by taking in whichever you fall, you can make that case and prove sexual harassment. So the first one is the quid pro quo, which is rejecting a supervisor's advances adversely affects the employees' tangible benefits such as raises or promotions, right? So here what is happening is that your supervisor is linking the unwelcome advances and he's demanding sexual favors in return for some tangible benefits such as the rewards or such as the pay raises or promotions or increments, etc. Right? So here what the supervisor is doing is that he is tying these tangible benefits with the sexual favors by the subordinate, right? So this is a very worst form of sexual harassment, in which all these things are tied with the with those rewards, right? And so if you want those rewards, you should enter into this kind of advances as per this arrangement, so the supervisor is linking these two together. Under the hostile environment which is created by the supervisors, what happens is that here the supervisor does not link those advances to those tangible rewards or benefits. So he does not make with you any promises that if you do this, then you will get this, right? But the element of unwelcome sexual advancement of physical or of physical nature or only worldly, that can of course be only worldly in one advancement as well, by word of mouth, that can also be there, right? So you're using such verbal language which is offensive and which is not decent language and sexually abusive language, right? So the supervisors can use any of these tools, right, for unwelcome sexual advances, right? So in the first case, he does not link them to the tangible rewards. In the second case, in the first case he does link them with the tangible rewards, and in the second case he does not link these advances with the tangible rewards. But these are the behaviors that substantially affect an employee's emotional and psychological ability, to the point that they affect the employee's ability to continue with the employee's job, right? So they become so hard for the employee to bear that it becomes difficult for the employee to continue with that job, right? We know that specifically this is so in the cultures like Pakistan, that often these such cases where we know that women are most common victim of this sexual harassment. The ratio of women being harassed is much bigger, right? Especially in the countries like Pakistan. So and here what happens is that most of the cases of the sexual harassment in the offices, they remain unreported, right? Women, they do not speak up about what is happening to them, right? So they don't speak, and they keep silent, and most of the cases silently they even quit their jobs, right? So this is what happens, that sometimes it makes the things so difficult for you, even psychologically it makes them so difficult for you. You cannot concentrate on your workplace, you cannot concentrate on your job, and you at the same time don't want to use the company's complaint procedure, right? And as a result you are even forced to quit the job, right? And then there are the hostile environment which is created by co-workers or the non-employees. That is also can also be a cause for sexual harassment, or that can also be a proof of sexual harassment. So these are the advances by the co-workers. It's not that the employer is only responsible for the the unwelcome sexual advances that have been carried out by the supervisor or by the management of the organization or by the co-worker, but it can also be the customers, right? So employer is also responsible for any unwelcome sexual advance that is being done by the customer of the employer in the workplace, right? So that can be, for example, due to the dress code that the employer wants the female members to wear. That can be a cause of sexual harassment or the sexual advancement or unfavorable acts on the part of the customers, right? So if that is the case, then employer is responsible that why the employer discriminated between the dress code for the females than for the males, right? Or why they were asked to wear a specific kind of dress which led to unwelcome advances on the part of the customers, clients, or it can of course be the co-workers or anybody else, right? So here in that third arrangement, what is happening is that the hostile environment is just created by the co-worker or by the non-employees, right? And it's causing the employee the psychological disharmony, and as a result of that, the employees can react in different ways. Some of them can report, and they can use the company's reporting procedure, and the other ones can even just leave silently quit the organization without reporting. So in quid pro quo, we need to remember this: it is not necessary for the employee to have suffered a tangible job action to win the case, right? And the employer in its defense must show that it took reasonable care to prevent and promptly correct any sexually harassing behavior, and that the employee unreasonably failed to take advantage of the employer's policy, right? So we saw that how the employee can prove his sexual harassment case, and the employer what he needs to do when he is facing these allegations of the sexual harassment. Employer needs to show that okay, there was nothing wrong with the environment, there was nothing wrong with the policy. The policy was in place. The employees, they were well informed of the policy. They were well informed of what are the different consequences of the different kinds of unwelcome acts, right? And so the employer played its role, but still it was because of the employee's behavior, employee's unreasonable behavior, that he did not take advantage of the employer's policy, and because of that the incident happened. So that is the plea that an employer can take, or that is the defense that the employer can take. So what are the different laws in Pakistan on sexual harassment? I just collected all this information on the Google, and you can do that as well, because of course all this information, it won't be available in any book which you will be reading on the Equal Opportunity, because those books are mostly written by the foreign authors, and there the laws in America are reported mostly, right? Because and the book from which this material or this topic was prepared, there is also a book written by a US author, and in that all the examples and all the laws and everything was reported about relating the US, what is happening there. So I thought that it is important that I should introduce you with some laws that are in Pakistan on all these different issues, right? So I have made 1 or 2 slides on all those different laws and what are the different procedures that the organizations must adopt when they're faced with this kind of cases. So the first law that we have is the Protection Against Harassment of Women at the Workplace Act of 2010. Then this law or this act, it also gives us a complaint procedure that if an employee or there is a victim in the workplace of sexual harassment, or there is what should the organization do, what should be the complaint procedure that the organization should follow. So the first thing that the organization needs to do is that it needs to set up an inquiry committee. After the incident has happened, the organization must establish an inquiry committee, and this committee should be established within 30 days of the occurrence of such incident, right? And then 3 members, they should be appointed with at least 1 woman, 1 senior management member, and 1 senior representative of employee, right? So what should constitute this inquiry committee? There should be the 3 members. One should be a senior member, one should be a member from one should be an employee representative, or if there is not a labor union, we can also have one or two members from outside the organization, but one member should at least one member needs to be a woman. So all these three people, they in different combinations, they can, if the organization does not have them, we can also arrange them from outside the organization, right, and make their designations. And from all these three members, you need to there will be one chairperson who will be designated from amongst them. Right, and this inquiry committee, it will be within 3 days of the receipt of the written complaint, shall issue a charge sheet against the accused and seek reply within 7 days. So it has 3 days to issue the charge sheet, the inquiry committee, and then after it has issued the charge sheet, it needs to get the reply within 7 days. Then it will the inquiry committee is responsible to collect the evidence and statements from the both parties, that is from the victim and the harasser. It needs to get the evidence, and it needs to understand, and it needs to examine well the situation, and it needs to ascertain the facts about both the parties that are involved in the sexual harassment activity. Then the inquiry committee shall submit its observations to the final authority within 30 days of the initiation of the inquiry committee, right? So it has the 30 days to report or to submit a final report to the final or to the decision making authority, and if the accused is found guilty, it can report the same along with recommendation of minor or major penalties. Okay, so what are the different appeal process which or what are the different rights that the victim and the harasser has when it comes to the appeal process? So under section 7 of the Act, any aggrieved party can appeal the decision of a competent authority within 30 days of the written communication of the decision. So it is the right of both the parties, the aggrieved and as well as the harasser. They can file an appeal to the competent authority within 30 days of the written communication of the decision that has taken place, right? Which would be if any of the parties found guilty, it would be in the form of minor or major penalties to the party who is found guilty. So the appellate authority, it can confirm, set aside, modify the decision within 30 days from the appeal, and must communicate the same to both the parties again in writing. If there is any change in the decision as a result of that appeal, the final authority needs to revise that decision or needs to make the amendment, and within 30 days again it needs to report the same to the two parties. So even if there is not a change, then it needs to inform the two parties in writing that earlier or the past decision is intact and there is no change in that decision. So what should employers do to minimize the liability in sexual harassment claims? That's the question. First, when the employers, they're faced with this kind of sexual harassment claims or the complaints, when the sexual harassment incident has taken in the workplace and it has been reported to the employer, the first thing the management or the employer needs to do is that it needs to take it seriously. It must not handle those cases seriously, because otherwise they can create an even more abusive work environment, even a more hostile work environment, and it can lead to the increases in this kind of incidents on one hand, and it can be very bad for employee morale and for the employee behaviors, right? And it can of course increase the court cases and the lawsuits that the firm must face, and it can invite bad reputation of the company. On one hand, it can invite the economic and the financial losses that the organization faces on the other hand, and it can be very detrimental to the motivation of the workers, right? So they must take those complaints seriously. Then they should issue a strong policy statement that should condemn such behavior. Right, of course there needs to be a clear-cut and very strong and very well communicated policy which should be demonstrating both the rights and the responsibilities of the employees, right, and on how they have to behave ethically in the workplace, right, and how certain acts and the certain advances, they are unwelcome. So there should be very clear sexual harassment policy at the workplace, and it should not be tolerated in the organization. Then develop and implement a complaint procedure right? So if any such incident happens, there should be a proper complaint procedure, and it should be a formal procedure, and it should be a step-by-step procedure. Then you need to establish a management response system that includes an immediate reaction and investigation by senior management. So that as a result of that complaint procedure, when the complaint is filed by the aggrieved party, there should be a management response system in which the management needs to handle the complaint that has been filed with it, and it needs to make an immediate reaction, as I told you, and it needs to make a very well investigation of the complaint by involving or by collecting data from both the parties, and by cross-examining the situation and the two parties' cases, right, and by cross-examining the various clues it gets from the two sides. Of course, there should be the management training sessions with the supervisors and the managers to increase their awareness on the issues. So sometimes what happens is that the managers, and the supervisors, they don't have themselves the capacity to deal with such issues. They're not aware on such issues. They're not aware on the different laws and the regulations relating to such issues, and they don't simply know how to handle such issues, right? They're either too casual about those issues, they're ill-trained about those issues. So they should be formally trained on those issues. That is really important, right? That the managers and the supervisors, because they have to deal with those cases, they're running that management response system, therefore they should be very well aware on how to handle those cases. Then discipline the managers and employees who are involved in harassment, right? If the managers, of course, whoever is involved in that harassment, you need to discipline that employee. And how you're going to discipline the employee? You're going to impose either the minor penalties, or you're going to impose the major penalties, and that is the way of disciplining the employees or the managers, whoever is involved in the harassment. And we'll be talking in detail about all these different aspects in our future slides as well. So you need to keep records of the complaints, investigations, and actions taken, and you need to conduct exit interviews that uncover any complaints and that acknowledge by signature the reasons for leaving. I told you, I think in one of my previous lectures as well, the importance of exit interviews, because these interviews, they are basically, through these interviews, the organization really can get its very true picture of how the organizational policies and how the organizational actions, how the different initiatives by the organization, they are being perceived by the employees. Or it also gives us a very clear idea, very candid opinion of the employees who are exiting the organization on what were the actual reasons of their exiting the organization, right? What were their sources of dissatisfaction with the organization? What was their sources of turnover with the organization? So we can get to know the actual reasons. You also need to republish the sexual harassment policy periodically. So what happens is that is basically a way of reinforcement to the employees that you are that shows that you are continually committed to a cause, and you're concerned and you're taking seriously the cause. So it is sending the employees the strong signals about the organizational policy. Then encourage upward communication through periodic written attitude surveys, hotlines, suggestion boxes, and other feedback procedures. So upward communication that can take place, as we all know, that upward communication is the one which is starting from the low level employees, and it is going to the upper levels in the management, right? So there are a number of ways that how the upper management can hear the voice of the low level employees, such as it can conduct those attitudinal surveys in which you can seek the opinion of the employees, that how they perceive the different in the environment in the organization, and the different policies in the organization, and the different issues that they are facing, etc., right? And how satisfied they are with the organization, and so on. You can get to know the opinion and of the employees in a number of ways, on a number of areas, through these attitudinal surveys. And some organizations, they have also put up these suggestion boxes wherein the customers, they can put in their suggestions, the employees, they can put in their suggestions, and so on, right? And those can also be helpful because they are anonymous also, and you can get to know if there are any problems that the organization is facing, or the employees are facing, or how they are feeling about it. And there can be a number of other feedback procedures that can help you understand that how your management response system is like, and how you are handling the different procedures or the policies, or what is going wrong, if anything, anywhere. So there are different state and local employment, equal employment opportunity laws, such as the effect of the state and local laws is usually to further restrict employers' treatment of job applicants and employees. Right, and state and local laws, they cannot conflict with federal law but can extend coverage to additional protected groups. So the laws that you make and the local laws of the organization, they cannot be in conflict with the federal laws, although you can make more stricter laws than the federal laws, right? But you need to abide by the federal laws and you need to remain within that jurisdiction. Okay, there are a number of different types of of discrimination that can take place in the workplace, right? Discrimination, it can relate to people who, based on their gender, on their race, their color, their culture, their background, norms and values. So that is basically the racial discrimination, right? Then organizations can also have this disability discrimination, which is the discriminating the people based on their physical and mental disability, illness and age, right? So it is basically related to the disabilities of the people on the physical grounds or on the mental grounds. Then the gender discriminating, where you are discriminating between the different employees or the prospective employees on the basis of their gender, on the basis of their being male or females, right? So we have often witnessed this. Gender discrimination is really very common, although the other types of discrimination are also common, but this gender discrimination is especially very common in the organizations. Wherein at the time, it starts at the time of the recruitment, and then it goes to the selection process, and wherein you give your bias towards men against females, and you have this general perception that that the female workers, they cannot perform as well as the male workers, or the females cannot do those difficult and the managerial tasks, and they are mostly kept in the lower level jobs, and such jobs are given to the males, even if the males and females, they're working on the same job, they have same job description, even then they are being differentiated against on the basis of their pays. The female worker is paid less compared to the male worker in the same job responsibility, in the same job position, and that is again based on this belief that the females, they are not that productive as the males, right? So that is all gender discrimination. Then we have this religious discrimination, wherein people are being discriminated against based on their religion and on their faithful affiliations, right? So these are all the different types of discrimination that can occur in the workplace, right? Sources of discrimination allegations. How again now you can prove that there is the discrimination taking place in the organization, right? So there are different ways by which the organizations, in the first place we need to understand that there are different ways by which the organizations, they enter into these discriminatory practices, and those the discriminatory practices that can both be intentional and they can be unintentional. So disparate treatment basically relates to the intentional discrimination which is done by the employer, and it treats an individual differently because that individual is a member of a particular race, gender, practice or the ethnic group, right? So that is basically the intentionally you form that such policy that you want one protected group or one class of workers, you don't want them to participate in your organizations or in your organizational activities. So you have made such policies and practices which are automatically restricting a particular race, religion, gender or ethnic group. So for example, we often see in the advertisements in the newspapers for job opportunities, in which it is often written that if there is a job for a receptionist, then you are writing that only female participants, only females can apply, right? So this is the disparate treatment, right? And there are some other jobs for them. It is again written that only the males can apply, or only the people belonging to this sect or this religion they can apply, and so on, right? So this is all the intentional and it is very clear, and it is intentional discrimination. Then the disparate impact is that where the policy is apparently neutral. We are not saying such things that as only the male can apply or only the female can apply. The policy is apparently neutral to every sector, every category of the workforce, but it still has an adverse impact on a particular segment of the work group, or on the protected class. It still has an adverse impact. So under the disparate treatment, for example, if you set a policy that the people who have the 18 years of education, they can apply for this job, and we know that there is a certain category of people, or for example, in the US, there are if they make this policy that only the higher educated people they can apply for the job, then we know that it will be discriminatory against the blacks. So more whites, they will go to the labor pool compared to the black. So this policy would be apparently this is a neutral policy, but then it is against a particular protected class. So this is disparate impact, and this kind of policies, it can basically adversely impact a particular class or a protected class, right? So adverse impact is the overall impact of employer practices that result in significantly higher percentages of members of minorities and other protected groups being rejected for employment, placement, or promotion, right? So in the example that I just gave you earlier, what happens is that as a result of that 18 years of your policy, a huge number of applicants, they become ineligible to apply. A huge number of potential applicants from the black work group, they are ineligible to apply as a result of this policy of 18 years of education, right? So it has adversely impacted that class of workers. How can you show that adverse impact is taking place, right? How can you prove adverse impact is taking place as the employees or as a member of the protected group or protected class? There are a number of options that you can use, such as the first one, if we consider it, is that disparate rejection rates. So in the disparate rejection rates, what you do is that you conduct a test that demonstrates that there is a discrepancy between the rates of rejection of the members of a protected group and of other groups. So you make a comparison between the rejection rates of the protected group and the other group, right? And if that rejection rate of the protected group is higher than that of the other groups, then it shows that there are disparate rejection rates, and the policy on the part of the employee is adversely impacting a particular work group. Fourth, fifth rule is of thumb is also used to see if there is adverse impact on one particular group. So herein the rule of thumb is that you 80% of the workforce, if more than 80% is the majority, right? And if the protected work group's hiring rate is less than 80% of the majority group, then there is a case for discrimination, which can be proven on the part of the victim, right? If the total out of the hirings, out of the total hiring that is being made from the majority work group, less than 80% of the people are being selected from the minority group, then it means that there is discrimination, and there is the adverse impact of the employer policy or the employee selection rates on the employees. Then we have the restricted policy. Under the restricted policy, what happens is that you have an employer's hiring practices which exclude a protected group, whether intentionally or not, right? So you have a restricted policy, whether that is intentional or that is unintentional, it is affecting the employee behavior. It is affecting the particular work group or a particular class. Then we have the population comparisons. What you can do is that you can just make comparisons of the percentage of the minority or the protected group and the white workers in the organization with the percentage of corresponding groups in the relevant labor market. So just make a comparison of your ratio of the minorities versus majority, or of the on the basis of the gender. Even you can take your ratio of female versus male, and the ratio that is being employed in the industry, in the local industry, right? What are the other organizations in the industry employing? What are their ratios about the particular race, or about a particular religion, or a particular gender? Then we also have this McDonnell-Douglas test, which is a test for disparate treatment in which the applicant was qualified, but the employer rejected the person and continued seeking applicants. So herein there are a number of conditions which are, if applying, then it means that that there is the adverse impact. So the first, the person needs to belong to a protected class, right? Then secondly, the person applied was also qualified for the job. So there is somebody who is belonging to the protected class, right? He applied for the job at the organization, and he qualified for that job, right? But he was still rejected for that job, right? He was disqualified. And then after his rejection, the organization continued to keep its hiring procedure open, right? It continues to continue to keep inviting the applications from the other applicants of the similar qualifications as the employee from the protected group that has been rejected, right? So it continues to seek the applications with the from the persons with the complainant's qualifications. So it is showing that there is something wrong in the adverse impact. It is adversely impacting the protected class, and there is some discrimination going on in the organization in its hiring procedure. Bona fide occupational qualifications, they are basically there are certain occupational requirements that make the policies of the organization non-discriminatory, right? Even we don't have the equal policies for the different categories, but those policies are non-discriminatory because they are based on the occupational qualification requirements in the different occupations, right? So it is the requirement that an employee be of certain religion, sex, or national origin where that is reasonably necessary to the organization's normal operation, right? So such as the age, it can be the bona fide occupational qualification when a person who is belonging to a certain age group, for example, as there is a 61 years old driver, and the organization might have a policy that the prospective candidates cannot be of age above 60 years, right? That can be that can be because the hiring the drivers beyond the age of 60, that can be very risky, and that can be more accident prone, because with old age you lose your reflexes, they are not that strong, and thus it can be to the jeopardy of a large number of people. Therefore age in this case is the bona fide occupational qualification, that owing to this requirement by the occupation, the organization has adopted this policy that people beyond this age limit, they cannot apply for this job, right? Then the religion again can be a bona fide occupational qualification when you can prove that the hiring from a particular religious group is a necessity for that occupation, right? For example, if there is a school in which you're giving the religious education on different religions, then of course you need to hire people from all those different religions who can give the education in their according to their religion, right? So then in that case the religion is a bona fide occupational qualification, right? And then the gender is a bona fide occupational qualification when it is possible for you to prove that or when a particular job that can only be performed by a particular gender only, right? Such as for the jobs of the actors, there are certain physical appearances that are required, and there are certain gender is required to certain job, right? So for example, the role only a female can do the role of a mother, right? So there, that is a bona fide occupational qualification to hire a gender from a specific category. Then you have this national origin, which can also again serve as the bona fide occupational qualification. So where you can prove that this is the requirement by the occupation, that is why you're adopting this practice, then that is not discriminatory practice. And again, for the business necessity, we see that it is a business necessity is when your organization and when you as an employer are able to prove that you are adopting certain practices because they are requirement of the business, then those practices do not remain the discriminatory discriminatory practices, right? So for example, if I gave you the example of the 18 years of education, that if that is required, right, and as a result, a number of a majority of blacks, they are out, they are down short, they are not shortlisted, and they are just they do not come under the in the net of the potential labor pool, then that practice is discriminatory. But if the organization is able to prove that 18 years of education is a requirement for the work to be done, right, then that does not remain a discriminatory practice. Unless and until you can prove that any practice that you're adopting is not discriminatory, then or that is a business requirement, that is a necessity to perform a job, then of course that is a business necessity, and that practice does not remain discriminatory. But you need to prove the validity. For example, in your selection procedure, if you're using certain types of tests, or if in your applications you are making this criteria that 18 years of education, that you also need to prove that that the practice that you are adopting is valid, which means that it will truly actually depict the performance, that 18 years of education is actually related in this job to higher performance. So if 18 years of education is not actually related to higher performance, then it means that practice is not valid, and you cannot adopt that practice, or you cannot hide behind that practice, or that practice is discriminatory, right? So validity is the degree to which the test or the other employment practice is related to or predicts performance on the job. Then there are other considerations in discriminatory practice defenses, such as the good intentions. They are no excuse. You cannot hide behind good intentions as an employer, that your intentions were good but still the practice was non-discriminatory, but on the basis of your good intentions you cannot take plea. Then employers cannot hide behind the collective bargaining agreements as well, that this was an agreement between the union, or the union asked us to do this as an employer, therefore this was adopted. You cannot hide behind that. And similarly, if a personnel practice is discriminatory, firms should react by agreeing to eliminate the illegal practices where and when required, by compensating the people discriminated against. So there are a number of discriminatory employment practices, such as the recruitment. In the recruitment, word of mouth, the employers, if they use, especially when the people or the workforce is in majority, for example, people are belonging to a particular race or religion, then if you'll be hiring through word of mouth, then these people, they will only be promoting their own religion or their own race, and thus chances are that your practice will become discriminatory, and it will be against the groups who are in minority. Similarly, the misleading information that cannot be provided by the employer when it comes to the different job opportunities. And the help wanted ads, they are again discriminatory, as I told you, that if the ads which are saying that females needed or the males needed, they are again discriminatory. Then the personal appearance, the hiring that you make on the basis of this personal appearance, such as on the basis of dress, your physical appearance, your hair, your uniforms, etc., that is again discriminatory, and that those practices should not be adopted. In the selection procedure, the educational requirements that they can be discriminatory, the preference to relatives, height, weight and physical characteristics. The arrest records, you cannot ask the employees about if their arrest history. And in the application forms, you cannot ask them about their marital status, gender, and other information unless and until you prove that these educational requirements or this height, weight, and physical characteristics. For example, in the jobs of the pilot, you need to have certain height and certain weight and etc. Therefore, that is the business necessity, or that is a bona fide occupational qualification. But in other jobs, if it cannot be proved that that is a business necessity or bona fide occupational qualification, then you cannot use any of these, right? They will become discriminatory. So questions to ask when an employer receives notice that Equal Employment Opportunity Commission has filed a bias complaint. So you need to ask, or what can be asked is that exactly what is the charge, and is your company covered by the relevant statutes? What protected group does the employee belong to? Is the Equal Employment Opportunity Council claiming disparate impact or disparate treatment? Are there any obvious based upon which you can challenge and or rebut the claim, and so on. There are a number of different questions that can be asked, or that you need to ask yourself. Then the Pakistan's law on workforce diversity. There are a number of laws in Pakistan on how to manage this diversity. So diversity rights of disabled people to the National Policy for Persons with Disabilities 2002, and according to this, the Employment and Rehabilitation Ordinance of 1981, it ensures that 1% quota for employees in organizations, which was increased to 2% through the modification of the National Labour Policy for Persons with Disabilities 2002. So we see that there are a number of acts in Pakistani law which protect against that discrimination based on disabilities, right? Then there are incentives to employers also who employ disabled people, and honor the quota system in terms of financial assistance and priority approval of contracts, shipments or material, thus encouraging the employment of persons with disabilities. So there are a number of laws on workforce diversity in Pakistan, such as the women rights, there is this through the Pakistan Factories Act 1934. Then there is the Constitution of Pakistan 1973, which talks about the maternity benefits, right? And then Pakistan Civil Rights Act 1964, which talks about this equal employment. And we have the child care benefits under the Pakistan Factories Act 1934, and then there are a number of other laws. So we see that we have comprehensive laws on all the different areas when it comes to Pakistani law and legislation, right? And but unfortunately, mostly the organizations, they are not aware of these laws. The employees are not aware of them. As a result, employees are not available of their rights and of their responsibilities as well. So diversity management, we all know that it is the workforce diversity is on the rise as a result of the globalization and as a result of the international mobility of labor. Now we can see everywhere more and more people of different color, different race, different sexes, different national origins, etc., right? So as a result, the diversity training is a must, diversity education is the must, because diversity can have both the potential benefits and the potential losses for the organization, or it can be a challenge for the management as well, in the form of conflicts that can arise when the people from different backgrounds are coming together and working together. Then a certain conflicts can arise between them, and it's a challenge for the management to understand that how the management needs to get formal, the supervisors need to get formal diversity training on how they have to handle the conflicts if they arise between the diverse workforce. Because we know that for once the conflict is functional up to a certain level where you can reap the benefits of the conflict, but beyond a certain level the conflict becomes dysfunctional, especially if the conflict between the two members in a work group it arises on the basis of their interpersonal relationships. Then that conflict is dysfunctional and it is not helpful for the organization. But if that conflict is based on task, on the performance of the task, on the procedures used, then that conflict can be beneficial for the organization, that can be healthy for the organization, because it can encourage the different other options, different better ways of doing things, and it can challenge the status quo, right? So they are the benefits of the conflict, but that can also turn into potential losses if the managers and the supervisors are not properly trained, and the employees are not given the training on diversity, on how they have to work together when they are belonging to the different categories and the different backgrounds. Of course, the diversity initiative is effective. There are when we are talking about this diversity management in the workplace, as an organization, as a manager, we need to ask ourselves that are there women and minorities that are reporting directly to senior managers, and do those women and women, they also have the fair share of job assignments, right, that are stepping stones to successful careers in the company. As I told you earlier, are they given important positions in the organizations? Do they have access to international assignments? Are they in the career development or pipeline or not, right? Then this equal employment opportunity, which is wherein we talk about the provision of the equal employment opportunities to all the different categories of workers, whatever sex, whatever religion, whatever disability, whatever national origin or age or sex they belong to. But affirmative action, on the other hand, it is basically a corrective action which is taken by the employer when it feels that in the past there were certain discriminatory practices which were used by the employer or by the organization, as a result of which a particular protected group or a particular class of workers that was that is not being represented well, and it wants to correct that practice of the past, and as a result of that, this affirmative action is being used, in which employers, for example, set quotas. That, for example, they set quotas for females, they set quotas for a particular race or a particular religion, etc., in order to correct the misproportion of the past, or in order to correct the discriminatory practices of the past. You need to set quotas, or this is the affirmative action plan, right? So if we make a comparison between this diversity management and this affirmative action, we'll see that managing diversity is voluntary, but meeting this affirmative action requirements, that is often mandatory. Diversity management, it focuses on productivity, but the affirmative action, it focuses on legal, social, moral justifications, right? There can be certain, you are not meeting the legal requirements, right, that you are discriminating against a particular group or the particular class. To correct that, it might be mandatory for you to enter into this kind of initiatives, right? So it includes the diversity management includes all elements of diversity, whereas the affirmative action, it includes only race, gender and ethnicity. Diversity management, it emphasizes on the changing systems and operations, whereas the affirmative action emphasizes changing the mix of people, right? What proportion of people you need to introduce now, right? Offers up the diversity management offers a perception of equity, whereas the affirmative action offers the perception of preference, right? Because here when you are fixing quotas, right, of course you are preferring a certain work group, that you have to make a hiring from this work group, even if that those number of people, they may not be as qualified as the other category of people, but since they are not coming into that quota, they are not qualifying for that quota, therefore they are outrightly rejected, right? So you're giving the preference to a certain group of people in order to correct your previous actions, in order to correct your proportions, your ratios, right? Therefore here it is more on a perception of the preference than a perception of the equity, as in the case of diversity management. So diversity management is long-term and ongoing, whereas affirmative action is short-term and limited. When you make the corrections, necessary corrections, and you achieve your desired ratios, then these programs, they are gone. So diversity management is grounded in individuality, whereas affirmative action is grounded in assimilation. So there are a number of steps in the affirmative action program, and I will not go through all of them. They're very simple and straight, and you can just go through them. So it is the issue. It issues a written equal employment policy, appoints a top official to direct and implement the program, publicize the equal employment policy and affirmative action commitment, survey monitors and surveys minority and female employment to determine where affirmative action programs are especially desirable. You're right, you conduct your surveys, your audits in all the departments, and you see that where a particular category or the protected class is underrepresented, and then you develop these programs, you conduct your audits and your reporting systems, and you monitor and evaluate the progress of your programs, right? And then we see that how you can design an affirmative action program. It should be a good faith strategy aimed at changing practices that contributed to excluding or underutilized protected group, as I told you earlier. So increasing the minority or female applicant flow, demonstrating top management support for the equal opportunity, demonstrating equal employment commitment to the local community, keeping employees informed about the specifics of the affirmative action program, and broadening the work skills of the incumbent employees, right? Reverse discrimination is a concept which, as I told you earlier, that when you're introducing the program such as the affirmative action, so what you're doing is that you are basically setting the quota system, and you're hiring a particular number of people from a particular group, or from race or category, or gender or religion, and as a result the other group or the other category, they might have this feeling that they are being discriminated against, right? So that is the reverse discrimination. So this is a claim that due to the affirmative action quota systems, white males are discriminated against, and it is not only restricted to the white or black males or females, but it can also be to a number of other different categories, such as on the basis of the disabilities, on the basis of the religion, and so on. So with this we come to an end of this chapter of this lecture. Today we had a discussion on equal employment opportunity laws, what is discrimination, what are the different types of discrimination, what is sexual harassment, how the sexual harassment can be proved, right? What are the different defenses that the employer can take in these sexual harassment discrimination cases, what is Pakistani law on sexual harassment, what is the complaint procedure for sexual harassment cases, how the inquiry committee should set up, and how it should make its decisions, the minor and major penalties relating to the sexual harassment. And we also had a discussion on the diversity management and affirmative action programs, and we made a comparison between the diversity management and affirmative action programs. With this we come to an end of today's lecture. I hope today's lecture was really interesting for you. It was informative for you, because we also had a discussion on the different laws that are applicable in Pakistan, on organizations in Pakistan, and they are bound to follow those laws and legislations for the smooth working, and in order to avoid lawsuits and other court cases, right? They need to abide by those laws, right? So I hope it was helpful for you. Thank you for your patient hearing. See you again. Allah Hafiz.